thanks very much everybody for attending today's virtual boardroom about effective investigations. Today's session is being facilitated by Marion Hewitt, so I shall hand you over to Marion and we can get started. Thank you.
Thank you very much. It's nice to see people again. It feels like quite a while since I've done one of these one way and another. Right, is that working? Is the sound working? Yeah. So this is the first of a series of sessions that we've got planned through the autumn on much more sort of day-to-day HR things that we've been asked about. And this first one is around conducting investigations, which could be linked to a variety of situations. And it was going to be delivered by Nathan, and then as life happens and curveballs suddenly come into our world, he hasn't been able to make it today. But we've worked together different times over many years, so he's kindly prepared it, so I should be going through it and covering all the information that he was planning to share with you. So, covering today, it's about launching an investigation, considering the HR's role in the investigation, how we should support somebody in approaching it, suspension, what happens around the police involvement, the confidentiality side, the actual meetings, developing the questions, the framework for it, and then the actual investigation report. So quite a bit. And then at the end, those of you that come regularly know we do usually put you into a group for an opportunity to just reflect on things that you've picked up in here. So when we are launching an investigation, it's the first point is actually, what level of formality does it need? Sometimes it won't need a full formal investigation. Ideally, a lot of times we want to be dealing with things at an informal approach, but obviously we have to be guided by what the initial incident or allegation is and what internal policies and procedures would require us to do, because that comes back to this so many times with all of these things. Yes, we have the legal compliance, obviously, ACAS codes and things, and also, making sure we don't ever fall foul of our own internal policies and procedures, because that can then create a lot of risk further down the line. So think about the plan. How do you plan what needs to happen? So who will be the person carrying out the investigation? What are the terms of the reference? Consider the initial incident, allegation, whatever has come to light. Look at the timeline. Try and create a timeline. One of the things to be really mindful of in terms of sort of the good practice is how are you, going through the whole process in a really timely manner. So often things can just feel like they get so protracted, and that's to nobody's benefit. Regardless of what the ultimate outcome is, it's a stressful process for everybody involved. So make sure you put a timeline in at the beginning, again making sure that complies with any timeframes that are in your internal policies and procedures. Check out the detail of your own policies so that you can make sure that you've got all those things easily complied with. Check what the issues that have got to be dealt with, what type of evidence will be collated, what witness statements do you need, is there any CCTV footage you need, what documentation might you need access to, copies of, what IT logs, etc. might be relevant. So think about all the different elements that you might need when you're planning it. Who might need to be interviewed, and any specific arrangements that might need to be made for investigation meetings, and specifically what date will it be completed. So it might feel quite onerous, but actually putting that clear plan in at the beginning can be a really useful way of making sure it stays on track, and it's reducing minimum business risk. So, avoiding grievances, constructive dismissal claims, counterclaims, all of the things that I'm sure many of us have encountered over time. And this is always an interesting one, HR's role in the investigation. because we, hopefully all of us here that know, you know, the process, the disciplinary process and procedure, the outcomes, the investigation is not about what HR think and do. You know, so often it feels in organisations, you know, people seem to think that all the cases are, you know, HR's responsibility. HR said, whereas we should be the professional presence with the knowledge to guide good practice, whereas actually what happens and the outcome is owned by the relevant people within the business. And case law has been very clear that HR should not be overly involved in the investigation process, and further along, you know, again, they shouldn't be the ones that are deciding the outcome. Now, I recognise some of what we're talking about today. There are some challenges based on organisation size and the resources available and how you can separate out things. So, you know, it's always thinking about what is reasonable within the organisation that we're looking after. But it is for the person conducting the investigation to carry out the investigation and get the facts, and for them to reach their own conclusion. We should not be having any influencing role within that. Our role is around ensuring that the policy and procedure, the timelines are followed, and that it's presented in a way that is clear and concise. I mean, in terms of the background part, I would suggest the HR role, where it is crucial, is ensuring that managers are trained to be confident and competent to deal with these situations when they come up. So we should never be influencing things. Sometimes over the years it's quite scary when I've heard some of the things that people have said in terms of, you know, HR basically running it and deciding it, which it shouldn't be where we do. So approach of how would we approach the process? You know, impartial, no preconceptions, think about bias. I'm sure many of you will be able to identify cases where there's been yes, we can ask questions as we go along. Sorry, I've just seen so please either stick them in the chat or chip in. When we are looking at how we investigate something, that to me over the years has always been the biggest issue in terms of investigations. And if we're looking at good practice, that's what we want to make sure we're avoiding. People go out to prove the outcome they already believe is the situation. And by having that bias at the beginning, people can miss things that can make a huge difference to the wider case, to the level of you know, the business risk. You know, if there's huge gaps in something, that when it goes to appeal, or if it went further, if it hadn't been fully investigated rather than just gone out to find the evidence to prove what people already believe. So they need to be thorough and considered, you know, not doing the bare minimum. I mean, it has to be said that usually people aren't that keen to take on the role of undertaking investigations. You know, it's usually something that they're being asked to do on top of a day job. So certainly over my career, I don't recall people queuing up to be able to do investigations. But, you know, it is still important that they do it, because, you know, if it all goes wrong, you know, they will be involved later on down the line. You know, if things ever ended up in tribunal, I guess, you know, a lot of what you need to be thinking about is, you know, if I was to end up in tribunal, how would all this be covered? How would it look? They want to be considered and focused, and not to sort of, you know, go down rabbit holes. But having said that, still making sure that if something comes up that hadn't previously been included but it is definitely relevant, then you may have to broaden the scope of the investigation, but be mindful that we don't go from the original brief in terms of what the actual allegation might be. It's not about opening an investigation into everything relating to somebody. It's linked very much to the allegation. So our role there would be supporting the investigating officer. So helping them stay on track with the investigation, helping them collate the information into a report. So it might make sure things like, are we clearly informing the employee that it's taking place, adopting a reasonable time frame, checking that we are keeping to our own procedures, establishing facts, avoiding the bias, as I've said, and then being mindful of confidentiality. Doesn't want to move on. Suspension. Now, this is something that the thinking certainly has changed at different points in time. And the guidance now is definitely that we should only suspend when really critical to the situation. We all know that the standard letters that say this is a neutral action and all of that, but ultimately we know if somebody is suspended, it can never be a total neutral action. It will have an impact on how they're feeling. It has the potential to have an impact on their reputation. So however, from a purely objective point of view, it might be a neutral action, I would argue that there are always repercussions for people from it. So we would really only be looking at suspending somebody when there were real health and safety concerns, if that person were to be staying in the workplace, if there was a real risk to actually the integrity of the investigation, that idea they could tamper with evidence or intimidate witnesses, I think worst case scenarios. If there are further cases of misconduct that create greater seriousness, or if there's such damage to working relationships, there's potential to cause damage for the business. That last one is a bit more of a risky one, I think, but actually recognise we only suspend when there is a clear reason to do it. And actually we should review it. The fact somebody may need to be suspended initially, it doesn't mean they need to be suspended for the full period of the investigation. It may be that things change or as things progress. So make sure that it is reviewed. If it's communicated to other, it has to be as neutral as it can be. And recognise there can be wider repercussions if long-term suspensions could result in people, losing qualifications or the number of hours, or things that they need to have for certification purposes, there can be fallout from that. So be mindful of that. And another big risk for organisations if they suspend without pay if the contract of employment doesn't expressly permit it. Usually, or certainly I've had, usually suspension will be on full pay, but just recognise that part.
Marion, can I ask a quick question?
You can.
With now that so many people are working from home, do companies do a kind of a middle ground, which is you're not suspended, you can still work, but so things like intimidating witnesses, has that worked effectively in the past, which is you're not fully suspended, but you should work from home for the next week or so, and maybe choose, does that?
I think it's to me, I don't know what case law and things there is around it, and I'm happy to hear other people's views. I think it's all about reasonable risk, managing risk to the business, to the investigation, and making sure it's not coming from the belief that somebody is guilty. Is keeping them at work going to risk the integrity of the investigation or cause a genuine harm to the business? Mm-hmm. And if not, then I wouldn't see a need to suspend them. But it may be that you do adjustments. But I think it's about business risk ultimately to the procedures.
Yeah. Okay. Thank you.
So if the police become involved, sadly, there's not a straightforward answer to this one, as I'm sure you're aware. There isn't any specific rule about it. Sometimes the police may ask an organisation to put their internal investigation on hold if it might get in the way of a police investigation, but it does very much depend on the circumstance. And remember that the burden of proof is different in terms of criminal proceedings and employment outcomes. And the burden of proof is lesser. It's not for misconduct, it's the balance of probabilities, i.e. it's more likely that it's occurred, whereas obviously for a criminal, it's beyond reasonable doubt. So think about it from that perspective. What do your own policies tell you about what you can do in that situation? Is it practical? If a police investigation is going to take a long time, is it practical to wait, particularly if you're paying somebody if they have to be suspended? Can the business manage, if somebody is in a key role? So look at all those things, but, certainly, communicate with the police in relation to what is appropriate and what you're able to do. And certainly ACAS advice is that you don't have to await the outcome of police investigation before taking fair and reasonable action. Confidentiality. We need to do all that we can to maintain confidentiality, and the witness identity is a really challenging area. Otherwise, we could find ourselves with grievances and constructive dismissal claims and all sorts. And being mindful that obviously no information should be shared unless absolutely necessary. I mean, sometimes when you're interviewing a witness, you might have to share some documentation or some information that is relevant with them. And it can be a really difficult balancing act. A case that comes to my mind was a very severe allegation that was made by somebody and about one of the managers. That person was highly vulnerable. So they had it was about the confidentiality, the vulnerability, and how you could respect and maintain that whilst ensuring you were carrying out a thorough and fair investigation from the employee's perspective. But actually how you can carry out an investigation on something when you can only share limited information is a really challenging situation. So again, a lot of it is about what is reasonable. And actually, be mindful as to when you can and often you can't protect full identity of witnesses particularly. So we want to treat, or we would always treat, statements as confidential, but we can't always guarantee total anonymity, if you like, or we can't, but the confidentiality needs to be. Remember, in terms of the confidentiality, is sort of a bit of a side thing. An employee has the right to request access to any information that relates to them. So be mindful about emails that are going between people during the investigation procedure. As long as you're not actually including the employee's name or even the initials can make it risky. And check at trails of emails, because it only needs somebody to put a name in somewhere in a trail, and that employee can have access to the emails. So be very mindful around that. Anything else to think about that? Anything anybody wants to add? So protecting the anonymity of witnesses. Would doing that prevent the employee being able to represent themselves properly? Would it prejudice the investigation? The example I just gave. But recognizing when you can, it's very difficult to promise that, I think. The actual investigation meetings. Again, our role is very much helping and supporting the person carrying out the investigation, helping them plan the questions that they might want to ask, the logistics, and helping with meeting invites and the practical side of it. Ros, I can see a hand up.
Yes, can you hear me?
Yeah.
Oh, excellent. Yes, I just wanted to ask regarding an investigation, at what point in the investigation would you be expected to disclose everything that you have? Would it be at the investigation interview? The formal investigation interview?
Sorry, say that. So everything. So when you're interviewing the employee, disclose everything that you have at that stage.
Yes, I've got a bit of a difficult case at the moment where the person's gone sick, has refused to enter into the informal process, so refused to come to informal meetings. So we've now gone formal, and they are demanding that we send all the evidence we have to their home address for them to view before the investigation meeting. And I didn't think we had to do that, that actually the investigation meeting is the point at which you will say to the person there, or the informal meeting, had she come to that, here are the allegations, and then the full disclosure of all documentation only has to happen if and when they are called to a formal disciplinary hearing.
I would go with that, because the investigation, I mean, you advise them what the allegation is about, you advise them as the purpose of the meeting, but the investigation is to get their perspective in relation to the allegation. So I would only share, and I'm being interested in other people's opinions on this, so please join in now, or please do that. But yeah, only something that's relevant at that point in time, rather than needing to disclose everything, because that could influence responses. Other thoughts, please?
Thank you.
Hi, sorry, I'm not visible because I'm having terrible hot flushes at the moment. I'm a lady of a certain age. Striking that balance I've always found really quite difficult, because you can't guarantee total confidentiality and anonymity, because if you do that, it will just stop a process quite often. And also, when you get to the court door, everything's disclosable anyway, because you need your witnesses. So striking that balance of it, and I mean, bearing in mind what we're actually doing here is, you know, arguably not even quasi-legal investigations. We actually afford more rights than you would in even a criminal trial, where the burden of proof is beyond reasonable doubt. And for somebody that works in HR but has a law background, it's always seemed kind of weird to me. I won't say my previous employer, but at my previous employer, I did witness what I can only describe as a pile-on by various complainants, because that organisation had a culture whereby the general messaging is if you're complaining of certain things, you are guaranteed anonymity. Yes. And in practice, you can't do that, because it's a point of natural justice that at some point you're going to have to face your accuser in the eye, and that person's going to need to point the finger and say, I accuse.
One of the
difficult one.
Yeah, absolutely. And one of the challenges or situations where I've seen things get more complicated is when you start getting linked to who's making allegations, you know, when you've linked to vulnerable people that are, you know, vulnerable adults, and, you know, it adds another whole complexity to it, because of, you know, protecting all parties and keeping all parties safe, as well as making sure ultimately it's a fair process in terms of the investigation from the employee. So it is, I'm looking with the chat as well. It's great, thank you.
I was just going to raise that, Marion, that Martin has put a comment to say the invite letter. Sorry, it's just gone off my screen now. The invite letter is specific enough around the investigation that they're able to prepare for the meeting. So he said that he's agreed with you.
Yeah, I mean, I would outline the nature of the allegation. I wouldn't necessarily say who it was from, but sometimes you can work that out.
But that's really where it comes back to, that you just can't ever promise anonymity, because, you know, if something's happened, and it had happened, then the person would know it had happened with, so it becomes kind of,
because you do need to be specific in the allegations. So, on X date, in the presence of 3 witnesses, it is alleged that you did X.
And what I have also found
to a colleague,
is different sectors view things differently as well. And a lot of that is linked to perspective they take of risk. How much they'll share, how much they won't. So some of it actually comes back to organisations' approaches to things. So I think, our role is always to be mitigating risk through and ensuring a fair and thorough process that complies with good practice. But as we know, we learn all these theories when we're learning, and then we get people that come into it and it all becomes a lot more complicated. So okay, so
is it worth putting in your policy then that you won't disclose all of the information at investigation stage, and perhaps that should it become appropriate, that would be disclosed as and when a final, disciplinary hearing is held? I'm just thinking you might then...
Personal view was I wouldn't say it would be something that goes into a policy.
Okay.
But that's a view. So interested in
ours doesn't mention that at investigation stage, but then it does mention when it gets to a disciplinary hearing that you will be supplied with copies of all evidence against you.
And I think I'm loving all the comment. I mean, it's recognising the investigation is exactly as it says. It's not the hearing, it's the investigation to ascertain where you go from here. So, if you need answers to questions when we're looking at planning the meetings, people are also, can I ask this? Well, if you need to have this information to have a thorough report and as an outcome from the investigation, you need to ask the question in a way, that's appropriate, obviously. So people who, when we're doing the meeting or the investigation officer is conducting the meetings, they should own the meetings. They should plan how they want to approach it. By all means, we're there as a support to help them do that. And, maybe their sort of note-taking capacity and all those sorts of things. But actually, the meeting is owned by the investigating person. We make sure it stays on track, basically. So things, that all the things that you need to say in terms of, but whether right to be accompanied and all those sorts of things. Sometimes companies include that, sometimes they don't. Not a requirement, a legal requirement is an investigation stage. Okay, and then the questions, the variety of questions, as we want to be asking open questions, but sometimes we need those closed ones to check on particular facts. We will need to probe, or the investigating officer will need to probe, but obviously not in an aggressive way. We are investigating, we're not trying. And those what else would it be helpful for me to understand about this situation? It gives an opportunity to include the things that might not have been covered elsewhere. And then the report, I mean, this needs to be, well, the outcome of the investigation will then be whether there's formal action, informal action, or no action at all. But the ultimate report should be clear, as concise as is reasonable given how complex something is, but also objective. So, the tips from ACAS in relation to what a investigation report should look like is avoiding the use of jargon, nicknames, use simple and appropriate language, always stick to the facts, include all the evidence that has been collected as part of the investigation, and explain any acronyms. So a good investigation would always include an introduction, the outline of the process followed, the findings, the conclusion, and the recommendations. So that was what Nathan had prepared for you, which I hope I've done justice in sharing on his behalf. And what I'm going to give you the opportunity to do is let's stop share. because there is a lot of good chats happening. So I know we'll lose people as soon as we do this, but I thought we'll risk it. Put you into some rooms. I would suggest, I don't know, 6-8 people in a room, and just give you an opportunity, key takeaways, things you want to discuss, challenge. A lot of these things, there aren't clear answers. It will be based on a case-by-case basis. But how are we doing for time? Yeah, is that all right?
Yeah, no problem.
Joe, can you put people into rooms?
How long, Marion?
Where are we? It's 2 minutes, about 8 minutes, and then we have a sort of a 5-minute wrap up. So yeah, Joe and I were just chatting, and so the challenges is that for a lot of these questions we're all raising, there isn't a very clear yes or no, right or wrong, because so often it's, you know, situation, organisation, you know, there are so many dependencies, quite apart from, you know, how case law and all that sort of thing changes things as we go. So yeah, what we can always be doing is our best in terms of supporting a best process. So what things were coming up in your discussion? Just looking through all the comments that were in the chat. Anything particular anybody would like to share here?
We were talking about what happens if someone refuses to come to an investigation, kind of all the different things. If they refuse to come in person, all the different things you can, you know, give them. Like you could have it, you can either have it online, or you can have it over the phone, or you can ask someone to make a written representation if you can be specific enough. So
yeah,
and also whether or not you've got something in your policy about if someone, you know, without good reason.
Yeah, that's worth having. Yeah. And it's back to that. If it came to tribunal, would you have evidence that you'd done all that was reasonable to have carried out that investigation and to get their input? Yeah. What other things? I know you were having good discussion because somebody said as you came back in. Any other thoughts? Any questions still in the chat? What we're going to do is we're going to save the chat, and we'll just check if there's anything that hasn't really been covered and get that back to you.
We were kind of talking about the variability in composition of panels and the like for hearings. Mm-hmm. It can go from, you know, one person being support, you know, HR in support of everybody that's there present, to a panel of 2 or 3, which would probably seem quite daunting and quite mob-handed in certain sectors. But you know, I mean, in the NHS, doctors' disciplinaries, for example, are only ever dealt with by very senior HR people, because, of course, if you end up losing your job as a doctor, you could potential ramifications for licenses to practice. Yeah. And people like Barts and the London have been wrapped over the knuckles for not allowing people to be accompanied and things throughout the entire process. There's been recent case law on that, but yeah, it wasn't discussed in our little group. But sometimes, even though most organisations I've worked in do not allow staff to be accompanied at the investigation stage, or, you know, your fact finding, I would always make concessions on that for people if I thought they had additional needs. So my letters and invites would cover that. You know, if a person needs an adjustment on equalities grounds, or you know, on health and disability grounds in particular, I would probably allow them to be accompanied. But also, what's the potential risk of allowing that anyway? I mean, yeah, not illegal. Wouldn't let them bring a lawyer or something. No, just actually, you know, a colleague. Or, yeah, no, absolutely. Yeah. But I mean, even if it's not in the policy and somebody asks, my you know, approach for it in terms of what's reasonable, you know, if it means that we're having a more effective meeting. Yeah, it's a reasonable adjustment to allow them to articulate what's gone on, really. Yeah. And that's what we want. You know, we want to make sure we're getting that fair process. So, you know,
I would just add is that I always, if that does happen, I always make it clear at the start in terms of what I see their role to be. Definitely. So that you don't get multiple answers to one question when the representative answers it and then the individual actually decides they don't like that answer and kind of gives a different answer. So I do really clear about what their role is at the start.
Yes, and I mean, invariably, that's actually not to respond. You know, they're there as moral support, effectively. Yeah.
But they can also clarify. They can also ask questions.
They can ask, and I think it's getting that sort of almost a group agreement thing, isn't it, at the beginning of the meeting, actually. And I've worked with some organisations that very clearly have almost a document that says this is the role, this is what you can do, this is what you can't do, and it just makes it clear for people. But I'm sure if we were here longer, we've all got loads of cases that we could draw on, nightmare things. And I think what I've found most over the years is where the biggest issues have been where an investigation has had too much bias. People have gone out to prove what they believe happened, and then they miss. I can remember a dismissal appeal I was supporting, and the wider commonly known information, it was fairly comfortably misconduct, but the investigation was not thorough, and there was nothing in the investigation that evidenced it. And you have to make a decision based on the evidence that's presented in the meeting, not anything that you might have picked up elsewhere. It's got to be a fair process. So I think that's the thing that my mantra always has always been, don't go out to prove what you believe to be the outcome, which is where people can often fall down.
That can actually be, sorry.
Go on, Elaine.
I think that's where the terms of reference are so important and what you're investigating.
Yeah, that's
to make sure that it is a fair and unbiased report.
What's the phrase? Fail to plan to fail. Yeah. And somebody else was about to say something.
Yes, all I was going to say is that's where some of the difficulty can come in. The thing you were talking about right at the beginning, where you were saying HR shouldn't be involved in the investigation. If you're trying to guide your investigator towards evidence that they're not even looking at, even though it is in the terms of reference. I've recently had one like that with a supposed experienced investigator, and they were just not putting it in, and I just couldn't. I had to say, you need to be looking at these things, but it is difficult because then have I then tainted that investigation?
Yes, it's the link between, are we influencing it or are we mitigating risk? And again, sorry, no clear cutoff, no clear line on all of this, which is why we always have these debates, I think. So I think we've pretty much wrapped up on time, but it's really good. Thank you for staying for the discussion bits. We say we've got a series of these coming up. One is around, Jo, you've got the proper titles, haven't you? One's in relation to grievances, one's in relation to disciplinaries, and then a couple in relation to managing absence. So those will be over the next few months that you'll get the details of, but much the same here, some sharing and then a lot of your sharing. You're all HR people, you've all got a lot of experience that is really helpful for everybody else. So thank you very much for the generous sharing of it today. So back to you, Jo.
Thanks very much, Marion. And also thanks very much to everybody for coming on today's session. I hope that you found it useful. As always, I'll send out an email this afternoon with details of the next event. The next event isn't until the 11th of October, which is a webinar about coaching to shine. So quite interesting for anybody that, is interested in that. Otherwise, thanks very much. Have a good afternoon. And thanks to Marion.